I want to welcome everyone to our June Provider Forum. My name is Dina Justice. I'm the COO of the ARC of Florida. And today we have Mitch Turner with All Provider Services. And he has got a very good background with Adult Protective Services, DCF, APD group homes. So I'm going to let him introduce himself, and then we will get into his presentation on group home licensing.
Well, thank you, Dina. It's a real pleasure to be here today. This is a first for me, so bear with me if I don't quite sound like a professional presenter. I am, as Dina said, I was with DCF most recently. I think I retired in 2017, and since then have been trying to help providers and those who are applying to be providers become proficient in and get their applications in and so on. Prior to that, prior to working with APD, I was with Department of Health. I retired from Department of Health too, and started a permit processing business. So I learned a lot about the building permit applications and what goes on in the various building departments. Before that, I was with Department of Health doing medical malpractice investigations. And before that, I was with DCF doing adult protective investigations. So I've had a varied background. And if you go back further, it's even more varied. But within the state of Florida, I've had a number of jobs that have led me to have a pretty good overview of what some of the various laws and rules are. And that's what I'm going to talk to you about today. The APD was set up under the Florida Statute 393, and they established in Florida Statute 419 what they call community residential homes. And Dina, if you could put up the first slide.
Wait, hang on 1 second. Let me share my screen.
Or if you want, maybe I can.
No, I got it.
You got it? Okay.
Let's see real quick. There we go.
Yeah, if you could
go
to
hang on 1 sec. Why was it? Let me make sure that we do. Okay, so you should be seeing it now.
Yeah, can you start from the beginning?
This is slide 1.
Yeah, but you got slide 2. Oh, I can see it. I don't know what others can see. So community residential home is a home in a regular neighborhood, and by definition of both Florida Statute 419 and 393, they are to be considered and treated as a single family residence, with the residence being considered a family unit. That's the law. Okay, now within 393, there are other regulations and qualifications for becoming a provider of residential habilitation, as it's called. And they include what the home must have. One of them is a fire alarm system. Nowhere in the statutes or the codes that regulate APD is there a regulation for fire sprinklers. So next slide. And that's what I'm been concentrating my efforts on lately, is the requirements for community residential homes. And I'd like you all to really use that term instead of group home, because it is a term that's defined by statute And group home is a term that's used in the building codes and fire codes and has a different meaning for most of the officials that you're going to have to deal with. Next slide. So the question is, do you have to install a fire sprinkler in your group home or your community residential home, as we're going to call it? A CRH, since it's a single family residence and is to be treated as such as far as local terms are concerned, well, we should not have to do anything that a single family home does not have to do. And so do you have to apply for a change of use? Well, if you were a family moving into a single family home, you wouldn't have to apply for a change of use. So my contention is that no, that should not be required, just like the sprinkler should not be required. Next slide. So what's the definition of a community residential home? Well, basically is that it is licensed by APD and a couple of other agencies, for instance, DCF, but we're going to concentrate on APD today. APD, once you are licensed by them, the rules and regulations that apply come from 65G-2 of the Florida Administrative Code. Next. So if you are licensed by APD, you are automatically a community residential home and should be treated as such. Next slide. So the Florida Statute 419 defines the community residential home, and it means a dwelling unit licensed to serve residents who are clients of, and as I said, Department of Elder Affairs or the Agency for Persons with Disabilities. Next slide. It talks about homes with 7 to 14 residents, but then it also talks about homes with 6 or fewer residents. It says that it shall be subject to the same local laws and ordinances applicable to other non-commercial residential facilities, residential family units in the area in which it is established. Now, to me, that's a very clear mandate that local communities are supposed to treat your community residential home as a single family residence, not as a group home, board and care home, assisted living facility, nursing home, or any other designation than a single family residence. Next slide. So, next slide. Thank you. So as I just read this one, that the single family units, according to any local rules, regulations, ordinances, codes, or whatever else they might try to spring on you when you are registering your community residential home. That is required because you have to contact the fire department for an inspection. Next slide. In statute 393, the qualifications and requirements for a community residential home are extensive. And I tell everybody that I work with, you must read 393. Florida Statute 393, next slide, is I call it the Bible. And in it, it establishes not establishes, it declares what the legislator intended when they set up APD and the community residential homes. Says that the greatest priority shall be given to the development and implementation of community-based services. This was a move away from the large facilities where people with developmental disabilities were housed. I don't know how many of you remember back in, I think it was in the 80s, There was a big scandal in Staten Island, New York, where the conditions in this large facility were the impetus for changing to a more community-based model for developmental disability patients patients and how they were housed. Next slide. So the Florida legislature established these homes, and it said that the people who live in licensed community homes shall have a family living environment comparable to other Floridians, and that such residents shall be considered and treated as a functional equivalent of a family unit and not as an institution, business, or boarding home. So again, the Florida legislature has established how you are to be treated and considered. Next slide. There are basically three types of homes. There's the small home of 3 or less, where there's a live-in caregiver. APD calls that a foster home, not to be confused with the DCF foster home, but essentially that's the meaning of a foster home for APD is 3 clients or fewer, where there is a live-in, or we'll call it a live-in staff. Then there's the group home by APD definition. Again, remember, this is a community residential home that has anywhere from 4 up to, I believe, 8. And then there's a category for the larger facilities. But for the most part, we're going to talk about the homes with 6 or fewer. And so, next slide. Those homes of 6 or fewer are ruled by lots of administrative codes. You see the list here goes licensure of residential facilities 65G-2, but then there's 65G3, which has to do with providers, and 65G4, 5, 7, 8, and then there's 69A-38. That's the fire and safety standards for residential facilities for individuals with developmental disabilities. And I can tell you, in my years when I was monitoring group homes, I never read 69A-38. And I assumed that most of the rules for the safety and everything were already in 65G2, but they're not. So be aware that there are other rules that you might have to refer to, or that somebody might say, oh, you're not in compliance with. Next slide. Within 65G2, there are lots of rules and regulations about how to get licensed and what you and your staff can and cannot do, and what is expected of your treatment of the residents. Next slide. There's, in particular, in 69A, there are the standards for the fire safety, and in it, it refers to the National Fire Protection Association codes. NFPA is a national code that most states and or municipalities refer to as their standard. Next slide. So in the 65G2, it talks about the fire safety standards, but it refers you, as you can see in the second line there, that they shall annually inspect the facility for compliance with Chapter 69A-38. And that's where the problem comes in. Because you have to get a fire inspection, you go to the local fire marshal. Yep. Oh, okay. And you ask them to do the safety inspection, and they tell you, well, you got to go to the building department. And you say, well, why do I have to go to the building department? I'm not doing any building. And they tell you, well, because you have to get a change of use application. You're now no longer a single family residence, you're a board and care residence. And once they convince you that you're board and care, then they can convince you that you have to have a sprinkler system. And I know many people who have done it, decided they didn't want to fight with the local jurisdiction. I have been fairly successful. Hillsborough County, City of Largo, City of Pinellas Park have all waived that. Next slide. Because in, I'm sorry. So in APD at apdcares.org, you can find the rules and steps for becoming a provider. The emergency plan is required, and like I said, the contacting the fire department is required.
Hey, Mitch, we do have a question about what
Yeah,
you
go ahead.
said. With that being said, how do we get around that?
Okay, so and that's what I'm gonna try to get to. And so let's go to the next slide. I think we'll get to it, and if we don't get to it, answer your question by the time I'm finished. We'll go back to that. The other place that you have to look is in the what's called the handbook. It's sometimes referred to as the iConnect handbook or the iBudget handbook. And that also sets up how to become a provider, what you need to do, the courses you need to take, and so on and so forth. Next slide. Within the handbook is the number of hours of staff requirements based on your the level of care that the client has. Shows you the minimum hours per week, and that's how you get paid. You're paid basically on the services that you're providing within your residence. Next slide. So in NFPA, Chapter 32 applies to new homes for developmental disabilities. And there are a statement in Chapter 32.2.2.231, sleeping rooms, other than those complying with 32 and so on, in living areas in facilities without a sprinkler system installed within according shall have a second means of escape. And so this is the way, next slide, to go around or to convince your local people that no, you don't have to install a sprinkler, because as long as you have egress windows, a secondary means of escape that meet the standard of having at least 5.7 square feet, a minimum height of the opening of 32 inches and a minimum of 20 inches wide, no more than 44 inches above the floor, you don't need a sprinkler. Now,
What
yeah,
about,
go ahead.
yeah, I'm sorry.
Go ahead.
A question is, could a provider purchase a townhome or condo that currently has a fire sprinkler system and use this for a group home?
Yes. Now, with a townhome or condos, you have to be careful about the covenants and rules and regulations of the condo. For instance, it may say that you cannot use it for other than a single family residence. Well, you are using it for a single family residence. There is a slight increase in traffic because you're going to have staff coming and going. But you need to read the rules and the documents of the condo association or the homeowners association for townhouse. So you technically you can be in those, but you have to be careful about how they're going to regulate you. Okay? Because they may have rules about parking, for instance. They can't say that you can't be there, but they can say that you can't have any cars parked on the street. Well, if you have two cars in the driveway and the third staff member pulls up, where are they going to leave their car? So that's where you can run into problems. Okay, next slide. So if your home has adequate windows for a 5.7 square foot opening, I'm sorry, 7.5 square foot opening, you should be considered a single family home, non-commercial use, and that's what you need to talk to those local officials about. This is a single family home by statute. There is a provision in the NFPA for having a home without sprinklers as long as it has secondary means of escape. Okay, next slide. Okay, the other thing that they're going to ask you for is a change of use, and that automatically puts you into a kind of a commercial use situation. And so you don't really want to agree to apply for a change of use because you, again, are a single family residence in a single family neighborhood, and your clients are to be considered a single, a family unit. And one of my arguments for in Largo was that if a family that of six moved into a house and four of them had some severe developmental disabilities and they had to have some help come in during the day or even overnight to help with those four individuals, they would not require you to have a change of use or a sprinkler system because you're a family. Well, by definition, Florida statutes say that your clients are a family. And so this is where you have to get into perhaps a little argument with your local officials because they're going to want to go with what they see as their code. Next slide. And that's all they do is look at their narrow codes. They don't look at the other statutes that they think don't apply to them. They don't look at what is best for you and your clients. They will try to go with their codes that say, well, if you are giving board and care to people, then you come under the building code commercial, and R3 or R4 is the category that they will say that you belong in, and therefore you have to have a sprinkler. So what can we do? My effort is to educate, agitate, and legislate. So what do I mean by that? I want to educate the local officials as to what the statutes actually say about our clients and what they say about our homes in terms of what things we must supply and how we must make sure that the clients are safe. Monthly fire drills, for instance, comprehensive emergency management plan, all of these things that a regular person wouldn't have to do. We also have to have a fire alarm that has a manual pull station. All of these things are requirements that are already in our codes. We don't need anything extra. Agitate. So that's getting more than just you involved. Get organizations, get groups, get there's strength in numbers. And so when one person comes to the fire department and says, no, I don't need a fire sprinkler, and they say, well, the building code says you do, they're not going to listen to you as quickly as they'll listen to a group of people who say the same thing. So if you can get a group behind you, either of local people or even a statewide organization like Empower Florida, or one of the other advocacy groups, that's a good idea. And finally, legislate. I want to get some of the legislators on our side to say that they could add a few words here and there to the statutes that would clarify what they mean. Next slide. So my feeling is that if, for instance, in 419, they added the words "and treated as," that might help clarify for building officials and others that the legislature really did intend for our homes to be treated as a single family residence, non-commercial residential use, and therefore not try to make us have fire sprinklers and apply for a change of use. Next. So this is what I've been doing. If you have any questions about eligibility or the qualifications or the requirements for group homes, I'm certainly available to help people do that. And maybe, Dina, we can, yeah. What kind of questions do we have today?
Is this going to be an available slide? Can we get the slideshow so we can refer to it as we get started?
Yes, we are going to send out a copy of this presentation to all that attended, and then we will put it on our YouTube channel by the end of the week as well.
Can you share the YouTube channel? This is my first time.
Yes, I will put it in the chat. Give me one moment.
Also, if anybody contacts me, I have a kind of form that you might use to talk to your local officials, has those statutes, and I'm willing to send it out to anybody who asks. It's basically a letter that says,
are you getting ready to move to the state of Florida and you care for a lot?
well, I'm sorry.
No, that was me.
Well, okay. Basically the format that I have is a letter of notification. In 419, it says that you have to notify the local officials, but they don't have to approve. You don't have to get permission. So the letter I have is just a basic 419, 393, 65G2 outline to them saying that I intend to establish a group home at such and such an address, operating under these parameters. And then, by the way, I called it a group home. Please don't call it a community residential home. Okay.
I have a question. Does it have to be gender specific?
No.
Because oh.
So a group home can be either single sex or it can be co-ed. There's nothing that prohibits you from having a co-ed home. Remember that the appropriateness of the residence is important as you decide or you get referrals for new residents. you have to evaluate how they will fit in with the people already in your home. So if the very first person you accept has a proclivity for having sexual problems or contact with people, then the next ones that you bring in, you're going to have to be careful about how they fit in with that first person. That's the only restriction or thing that you have to think about as far as having more than one sex in, males or all females. No, you don't have to. Can be co-ed.
I have a question. When I tried to get my home license through zoned, they told me that I had to apply for a special application for special exemption and go before the city and go before my HOA.
Okay, what was there another facility within 1,000 feet of the
No.
one that you?
She said
Okay.
HOA. She has a HOA, so she's in a community.
So the HOA required?
Because they
Or-
said that you can't have a business in the neighborhood.
Okay, and again, Florida statute 419 and 393 both say you are not a business.
Okay. So that's what I go back to the zoning guy and say, look over those.
Yeah,
rules.
but okay, so you tell me that the zoning person for the municipality or jurisdiction that you're in is the one who said you can't do it?
Right. He said
Okay.
that I would have to go before the city and have this special meeting and then so that I could get it zoned, because my house is already a adult family care home, so I was trying to transition into that. And then that's what he sent me the directions back and said that I would have to go in before the city and get a special exemption and then go to the HOA and get permission before I could do it.
He's wrong. But now, how do you deal with an official who is wrong? It has been one of the funds, because now you're stepping on somebody's ego and their authority that they feel like they have over you.
Exactly. That's how
Okay.
that's how he was coming off for real.
But I have a
Right.
question. I have a question. Did you apply though?
You're asking
The young lady, like, did she apply or is that just emailing back and forth with an official?
I was emailing, but when he sent me all this
Yeah,
paperwork, I
so
was like,
I would
did-
apply. I would apply and let them deny your application, not off of what someone is saying.
Apply with
there's
who?
nothing for you to apply for with the city or the county or wherever you work.
Right.
You are asking them, the only thing you're asking them to do is inspect
Zone.
you're asking zoning to say, yes, there's nobody within 1,000 feet.
Right.
You're not asking for their approval. You're asking to verify that there is no one else within, and then there's another category for 1,200 feet. So I usually just look 1,200 feet. If there's nobody, no other facility, an ALF nursing home or APD home within 1,200 feet, they cannot deny you. And you are not asking for permission. You're just asking them to verify, because that's one of the requirements of 419. And so show them Florida statute 419. Here's what it says I have to do, and here's what it says you have to do as a county or city for me to get my license.
Okay, so just to clarify, if I have a group home, not an ALF, it still can't be an ALF within 1,000 or 1,200 feet of a group home?
Yes, the categories that you're looking at are assisted living facilities, nursing homes, other foster homes for DCF. So
They all have to be
there's a list of what facilities you have to verify are not within 1,000 or 1,200 feet of the one where you want to make your home.
So where can I get a list of those types?
It's It's on 419. It's on the
Okay, okay.
form that you have for your in the I think it's in the handbook too, but certainly in 65G2 or 393, it tells you that you have to first contact DCF
So
and
I
ask
have to
them if
go
they have
to the
facilities. You
living
have to,
room there, the
excuse me?
lobby, because I need charge my phone because it's not the meeting down.
I didn't understand the question. I'm sorry.
We do have a couple questions in the chat. And I'm gonna go, let's see. One was about, do you need to own the home that you have to use for a group home?
No, you can rent a home, but if you rent, you must have a clause in the lease agreement that says that the owner understands that you're using it as a residence for APD clients.
And if the neighborhood is in an association, can the association not approve you to have that type of home in their community?
If they do, they are discriminating.
Hey,
So
Mitch.
again, just briefly, the law says that you are a single family residence and that that the people that are living there are a family unit. That's the law. Okay, go ahead.
Hey, Mitch, my name is Kathleen Border. So we have group homes. We have one current licensed group home that we would like to increase capacity for. How do we go about doing that?
Okay, so I just recently did that in Clearwater. If you're going above 6, well, again, it depends on the municipality. In Clearwater, it was 7 or more people moved it into a different category, and they had some requirements about parking. For every 2 residents, there had to be 1 parking space. They had some other requirements as well, but that was the main one that kept us from being able to expand because we couldn't get enough parking in where they wanted it. But so first check your local codes. Do a search in the codes for community residential homes. If they have community residential homes in their code, it will say for code, homes with 6 or fewer, and then for 7 and more might be the where the code is. But that's a code for the municipality, for the government, not for the homeowners association. That's a whole separate category of rules and regulations. The homeowners association or the condo association is a government unto itself and can establish rules and regulations. They cannot keep you out of the neighborhood because you are dealing with developmentally disabled people, and they can't keep you out of the neighborhood because you're a business. Because by statute, your residence is a residence. It's not a business.
So luckily,
I,
no homeowners association. What about county fire? I would have to do something with the fire inspector, correct?
You have to contact the fire inspector and have them inspect the home prior to anybody being in it, prior to you getting a license. However, what they did in Hillsborough County was have a special form for DCF and APD and I guess ACA licensed facilities so that they were not being treated like a regular business. They had a separate category. I'm not sure what Largo is doing because that we just got that last year, but you want essentially to just act like you were moving your family into a single family residence. However, because you are licensed by APD, they require a safety inspection. The safety inspection, all they're doing is checking to make sure that people could get out in time. And when you do your annual inspections, they're going to look at your fire drill log. They're going to make sure that your fire alarm works. They're going to make sure that in the initial one, if you don't have a sprinkler, that you meet the requirements for the secondary egress. That's all they should do.
So the fire inspection we already do, we're literally going from 6 individuals living in this home, licensed by APD for 6, but there's a room with a separate bathroom completely empty. So technically we can go to 7. When we reached out to APD to say we'd like to increase capacity by 1, they said you need to get a fire inspection to approve it, and they said you may have to deal with zoning. So I was just curious if you had a different, so I can obviously look at the code.
Because the statutes, like for instance, 419 separates the category of facilities with 6 or fewer residents shall be treated as a single family residence. So once you go into 7, you're moving into that new category, and you can be treated differently. So you might have to deal with the building department. You might have to, you would definitely have to get the fire inspection, because APD wants to know that if you have whatever number of clients you have in the home, that they can get out in a expeditious manner. In the fire code, that's stated as a 3-minute evacuation. The clients can have some assistance in that evacuation, but everybody should be able to get out in under 3 minutes. Most of the time when I was monitoring group homes, I required 2-minute evacuations, because if they can get out in 2 minutes, they can certainly get out in 3. Most of the time we are testing during the day, not during sleeping hours. Actually, our statute says that we have to have at least 1 in sleeping hours, but that's why if you can get out in 2 minutes while you're not sleeping, you could probably get out in 3 if you were sleeping. But again, to answer that question, if you're expanding to 7, you may run into problems with the locals. But read statute 419 and bring it with you when you go to apply, because that should be the rule that decides whether you have to go do anything extra or not.
Thank you
I
so
have
much.
a question, please. My question to you, I already have a group home in parish with the capacity of 5. I want to extend it to 12. I went to zoning, they said I can do that. But I heard you were talking about sprinkler system. They want me to have the sprinkler system because it's more than 6.
Right.
How can I avoid that? Because the sprinkler system, it's a lot of money.
Probably $35,000.
Yes.
You can't.
I can or I can't.
Cannot. The fire
Okay.
code, the building codes, and 419 all say that you have to comply with those extra requirements in order to have those extra clients.
Okay, but I heard you were talking about how we can avoid the sprinkler system if we residential
6
single
or under.
room.
for 6 or under.
or 6 or under. Okay, thank you so much.
Okay. Are there questions about any other requirements for group home or community residential homes?
So it's best, who do we get to find out? Like I live in Polk County. Who would I contact to find out what's the statutes for a community-based home in Polk County? Who would I call?
Well, there's a couple ways to find out. What I do is I go to on Google Polk County municipal codes. Now, there's a couple different things that will come up. There are some private people who collect all the different municipal codes, and they might want you to pay to get in and see the actual codes. But then if you get to the Polk County site and look up their codes, like I said, once you get into their code, do a search or find community residential home and see if they have any codes for that. And you have to also be careful to check and make sure that if you're in an unincorporated area of the county or in an incorporated, that would be like a city within Polk County. Okay, but if you assume that you're in unincorporated Polk County, just go to the Polk County official website, search for municipal codes, and then in the code, do a search for community residential home.
We have a
Okay.
few more questions. One is, how many bathrooms do you need for 6 residents?
2.
And how many people can live in the group home?
How many people can live in the group home? Well, if you're licensed for 6, that's how many people are living in the group home. Now, could you have a room for staff to sleep? So that really means 7 are living in the group home. Technically, you could have an office that has a bed in it or a couch or whatever. Typically, if you have 6 residents, you don't want your staff sleeping overnight. You want staff that is awake overnight for 6.
What about the number of bathrooms for 6 residents?
So 2. For every 3, you have to have a bathroom for every 3 residents. So if you go to 7 now, you're gonna have to have 3 bathrooms.
Gotcha. All right, I don't see, do we have any other questions for Mitch?
I had a question, not really about licensing, but about consulting. Do you guys offer any consulting?
Yes, I serve as a consultant to, like I said, both applicants and veteran providers
So
for all kinds of services, for everything.
Maybe we can put, when we send it out to all the registrants, Dina, maybe we can send his contact information. So
Well,
if
we
they
have
need
the
him for
numbers
consulting.
Yeah, we have the
Right, that's
number,
what
the
we're gonna
813
do.
number, but do you have an email?
Yes,
I include it.
Okay, thank you.
We are putting the presentation, we're sending it to everybody that does have Mitch's contact information. So
yeah,
we-
the last slide in the PowerPoint has my name, phone number, and email on it.
Thank you.
Appreciate this presentation, really educational. I do want to say that, we provide the service at the ARC of Florida for all providers in the state because we want everyone to improve, and we appreciate you doing this. And I know they're getting ready to do rulemaking with the new regulations on licensing, so you may get invited back within the year.
Yeah, I'm hoping to be involved in that. For instance, Clearwater, the city of Clearwater just informed me that they are looking at their city codes and how they treat community residential homes, and so I've asked them to let me, give them some input on that, because they, like a lot of other cities, are moving toward, because you see, the building code changed in 2017. And that's when a lot of municipalities started thinking they had to, upgrade what they were requiring from APD group homes. And so there's been an increasing trend in places that never used to require sprinklers, now requiring them. And there's been a whole move throughout the state. I mean, I even saw an opinion from the former attorney general, saying that when a community residential home applies and wants to use 419 as their basis for that they still have to go and get a change of use and put the sprinklers in. That was his opinion. Now, so municipalities see that opinion and they say, oh, well, geez, we better require sprinklers. I'm hoping that by the time before I really retire, that I can get them to change that opinion so that everybody knows that a single family home is a single family home, whether it's licensed by APD or just happens to have a family living in it.
Hey, Mitch, I've got one question for you. You mentioned potential staff being able to stay or sleep in the office on the property if it's licensed for 5 or less. Is there any citation or code that specifically says that?
No, but there's none that says they have to be awake either.
Okay, gray area. I like it. Thank you.
Yeah, and it's for 6. Everything I'm talking about is basically for 6 or under. I have not seen anything in the code that requires the overnight staff in a home with 6 to be awake at all times. They should be available. They should be easily awakened. But if they're taking a nap while everybody else is asleep, that's not against the codes or statutes.
Right.
So I have a quick question. So as far as like within a year's time frame, how many group homes are we able to open?
As many as you want, as many as you can afford.
Okay, thank you.